And
Yeah. We still got a couple minutes, I'm just starting.
one of the main pieces is that dictatorship bad, freedom good. And you know.
Different room.
Yeah.
We have daylight at least. Nice.
Right.
Austin, I'm sending you what we've got.
Okay,
It's only one actual document, but then we've got commentary on three more, so.
okay. But I always go in the opposite way too as well.
Okay.
Feel free to sit at the table, just keep remarks
Yeah. Yeah.
amongst
If
yourselves.
you feel like seats further away, and then as we get closer, we need them, that's fine. Yeah, we have a couple along the wall that are still open, so.
You can totally sit, just.
Yeah, I'll ask.
I can move too if you need more
Well,
room.
you got one right here. Come on. It's all right. Here, look, take out your. They can all.
Bargaining session?
Yes.
Can I just sit and?
Yeah,
yeah,
if you
just over
wouldn't mind.
Yeah, if you would sit over there, yeah,
There's more.
it's a bit of a tighter room, but
Getting a little harder.
Yeah, sorry, we did request a larger room, but it was not available. That's why we're in a smaller room today.
Well, we have to have a bit of view today.
Thank you for coming.
It's gonna be good though.
well, let me open, I got your email, well, let me open the document to download it, but it will let me open it in browser, so I will.
Okay.
This is me pulling it up, but we can go through it once
Alright.
we get going, just pulling it up properly here.
Is,
Robert just entered the waiting room, so.
and let me know as soon as Michael's here and then we can.
Yeah.
Go ahead and find a seat where you can.
It's weird. Yeah, I think it's just my favorite guy.
Can everyone on Zoom hear us?
Yes.
Yes.
Thank you.
Thank you, guys. Okay, and we got Michael in here now as well.
We're ready to go then.
Okay, Zoom has been going, so, do you guys wanna go first for the one you have for 25? You want us to go? We have a couple for you.
Yeah, I mean, we don't mind going first if you'd prefer that. We're happy to do it either way.
Yep, yeah, let's do that. That works out perfect.
All right,
Hey, guys,
so,
let me share my screen.
so I
Okay.
think, so we've got four we wanted to sort of talk about. One that we have a counter, two that we're gonna talk about basically just accepting, and then one that we have more of a severability. I actually put a chart together to try to review and talk about rather than
Okay.
giving a proposal, but you've got that one up, so let's talk about that one.
Yeah,
Yeah. So I had a hard time, I didn't get, unfortunately, Austin, I didn't get your email until after I retyped it, so it's gonna show. Some of the stuff that's showing as a change is stuff that was actually in yours, cause I typed on my previous one, so it's showing as a change, so.
yeah,
Obviously, read it next to that one, I think. We kind of said this at the table last time with respect to duration, we want a hard and fast year. As opposed to having like a floating date.
okay,
And we estimate that to be through June 30th of 2028, hopefully based on the sort of the schedule we're on. But again, if we want to put this one aside and wait, I understand if that would make you more comfortable, that's okay. So because we contemplate the January 1 date and sort of all the other provisions, that's what we're suggesting for 25.2, negotiations for the successor agreement shall begin no earlier than January 1, 2028.
okay,
Article 10 shouldn't have any changes. 25.4. Article 12, health insurance shall be reopened each year. This reopening shall start no earlier than January 1. I believe that's the language that you all had suggested.
yeah, because we've already put that in the health care insurance, so just make sure it works
Right.
with the articles.
And then I think the other change was one that was already in your proposal as well, which is down in line 1920, except as mutually agreed. So, I mean, check it against yours, because like I said, I manually typed this based on the paper you had, so,
It looks like you didn't catch the issue in 25.6.
which was one.
Reopen negotiations under 25.2 and 25.3, but they're now 0.3 and 0.4.
Oh,
Yeah.
gotcha.
Which is
That's
minor,
my
but,
mistake. No, it's important.
Yeah, and
That's my fault. That wasn't intentional.
yeah, and then, okay, so we had negotiated, or we had proposed last time opening negotiations a year following.
Correct.
But prior to
Yes.
expiration, this is a 6 months.
Correct.
Okay.
Yeah, right.
So it'd be a shorter negotiation time frame is what you're
Right.
proposing here. Okay, yeah, I think this is probably gonna be one of those last things to do, just to make sure we get that date nailed down that you
Okay.
guys want to. We'll go back and we'll talk and see how we feel about the 6 months versus the year. Obviously, negotiations this time have gone quite over a year, so we want to make sure we have ample enough time without making us start negotiations as soon as we finish here, so yeah, that sounds good.
Okay. With respect to Article 4,
Okay,
I think we're prepared to accept, we were down to one word in 4.
yeah, I
which
think it's just
was
an and
or, I think we're ready to accept your and.
okay,
So, I mean, assuming I haven't done, it's a long article, I haven't done a word by word comparison of your last one versus our last one, but assuming there was no other changes, we're ready to accept that one, and if you want me to, I can load that one into DocuSign.
that sounds perfect, yes.
Unless you want to have any more discussion on that one.
if you don't mind, I'm just gonna do a quick explanation for anyone. Article 4 is our appointments, reappointments, and terminations article. And the and/or situation that we're talking about is for summer appointments. UF has asked for a tuition waiver exception, meaning that they would not pay a tuition waiver for certain GAs. And we have said that that can only be in the case that you are a 9-month GA working outside of your department and in a different capacity than you usually work. So if you're usually a TA and you are doing
Okay.
RA shit outside your department, would be the only situation in which you could have your tuition waiver not paid.
And this is based off of an MOU we signed over last summer where we did very much kind of the same thing. We've workshopped the language and that trial run last year, we didn't have any issues with that. So this is a very much a very limited kind of exception to allow departments who couldn't otherwise afford to have a GA over the summer, still have someone hired to do that work, but keeping it limited to make sure GAs still get their tuition waiver when they need it, you know? Okay,
Good
yeah,
on
Thank
that
you.
one? Okay, so I think in 7, we are also ready to accept may versus must, which was the only word that was left on 7. And that was with respect to whether or not GAs have responsibility to take actions if when at the point at which they believe they're being overworked. You know, we had kind of gone back and forth about may versus must, you know, we're willing to accept the word may.
Okay,
So unless there's any other changes on that one, I think that one's ready to go.
Yeah, I think that's good. If you want to send that one over DocuSign as well, we'll obviously review it before we sign it, but I
Right.
think we should be good there.
Okay, and then, so the last one is not a counter, but I kind of want, I know it's sort of very, very technical, but I put a chart together on Article 24 to
Okay,
try to make sure I understand. Like, so try to explain what our proposal was versus what we think your proposal is, and try to talk about some of the differences. I'm gonna apologize in advance because it is kind of technical and wordy,
Okay.
but I'm gonna do my best. Again, I'm just trying to make sure I
Are
understand.
there
It's,
two?
it's two, yeah.
okay.
One is
Let
our,
me give this one back to.
okay, yeah, one of them is ours and one of them is yours.
okay,
Can I do a quick summary for folks?
yeah, of course. Go for it.
Article 24 is severability. And we're talking specifically, considering all of the legislative actions that have been happening. We're talking about what happens when laws get passed that interfere or conflict with our contract. If they're then enjoined, partially held up, all of those different scenarios. So we're gonna now do a fun, like, what happens if sort of conversation.
Yeah, before we had this discussion, we had to do impact bargaining, which is what we do after something like that would happen. And for a lot of impact bargaining where it's currently stated, we had to sort of get rid of some of the language that we would have rather kept.
Mhm.
And so the argument was that there was nothing in the contract saying we could preserve that language as much as possible. And so we're adding those preservation kind of things in here for different steps throughout that process to ensure that a law being passed doesn't mean we immediately have to get rid of a ton of language. We can put something in there to say, this can no longer be enforced right now while it's going through the court system, things like that. So yeah, if you want to walk us through this.
Sure,
Patrick.
so, and,
Do we have one for the screen?
I don't think so.
oh,
Whatever
I can,
email,
I'm
though.
sorry, I don't know how showable it's gonna be because I did an Excel. I mean, I'll give you, I mean, you can try to put it up there.
Okay.
I don't know if it's gonna work or not. I was trying to put it in a way that would be like kind of show it in a cascade. I tried to do it as a full flow chart, but the bottom line is that there was so much text to put in there. It wound up being so big, it wasn't usable.
Right.
We could also potentially put up just the last article proposal we have.
Yeah, we can just do that. Pull that up.
It's on its way to you.
Okay, thank you.
So I think the first thing that you'll notice is that while it's on here for the purposes of trying to comprehensively capture the article, cases 1, 3, and 4 are effectively identical in both.
Okay,
So I'll go through them quickly, but I think that when you dissect the proposals, there's no difference in meaning or even in language affecting those three. So the first case is a provision is found to be invalid or unenforceable by a final tribunal of competent jurisdiction. And in both cases, the proposals we both exchanged say the party shall enter into immediate negotiations for the purpose of arriving at a mutually satisfactory replacement for such provision, regardless of whether or not the subsequent enacted legislation is the subject of a lawsuit challenging its enforceability. I know it's a mouthful, but I don't think I wasn't able to find a distinction when I looked at that case between our two proposals.
okay,
So I think those are the same. At least that's our analysis.
okay.
Okay, so let's
Yeah.
go down to number 3. So the third one is a provision shall have the effect of a loss. If the provision shall have the effect of a loss to the state of Florida or to the BOT of funds, property, or services made available through federal law, then it's the same exact language regarding what we do in that case. And I couldn't find any appreciable distinction between our two proposals. The language that applies was identical in both proposals, at least based on the way we're reading it.
Okay,
Similarly to the fourth case, which is not really the same as the first three, but it does talk about, the implications by section 447.309 regarding a mandatory power. And it basically says that that provision isn't of any force or effect, but the remainder of the agreement stays in place. And again, I couldn't find any difference between the two.
okay,
So it's all really in that second case. And the second case starts with the fact that the provision is rendered invalid by reason of subsequently enacted legislation, which is kind of what you were saying at the beginning when you were sort of introducing the topic.
yeah,
So this is where the difference starts. And again, I'm not necessarily, I want to make sure I understand. I'm going to try to do a better job explaining what we had previously proposed, and I want to try to explain what you all had proposed so that I can make sure I understand the differences. Because this is it's kind of arcane.
Do you
Alright.
mind pausing for just a moment?
Yeah, go
I just
for it.
wanna- That's very distracting.
thank you.
Okay, so when a provision is rendered invalid by reason of subsequently enacted legislation, right? The first part of it is the same in both. The party shall enter into immediate negotiations for the purpose of arriving at a mutually satisfactory replacement for such provision, regardless of whether or not the subsequently enacted legislation is the subject of a lawsuit challenging its enforceability, which is the same that applies in the other case above and the case below. The difference is what we had suggested was also adding language in that same case that would say, additionally, such replacement language must include considerations of which provisions are to be enforceable if the subsequently enacted legislation is enjoined, repealed, struck down, or amended in such a way that permits the previously invalidated provisions enforcement. So I believe that when you add that language the way that we've proposed it, the result is the cases on the right. So the three of the possible outcomes, not the only outcome, but the three contemplated outcomes are, in the first one, the legislation which rendered the provision invalid. So now we have a contract provision. Then there's subsequent legislation. Then that legislation gets enjoined, repealed, struck down, or amended, which now says you had a provision, it wasn't enforceable, but now the legislation which made it non-enforceable now has been enjoined.
Right.
Okay.
Can I just give a practical example? I think it's been working for us well of
Go
like
ahead.
dues deduction,
Okay.
right? So like I just want to make sure I understand what you're saying as well,
Sure.
right? Something that was in the contract became unenforceable by law.
Mm-hmm.
We go to impact bargaining. It's being talked about above our heads, right? And so now we're contemplating 3 different situations if it were to be enjoined, partially held, like that's what we're talking about, right?
Well, so slight modification of what you just said, because
Please.
the first thing that happened is we already had the impact bargaining is done.
Done.
Because that happens is the immediate effect.
Okay,
The immediate effect is that we have to enter into bargaining.
right.
So this is subsequent to that being completed,
Okay.
assuming it gets done.
Mhm.
Okay, so now we've already completed our impact bargaining.
Mm-hmm.
And now the legislation which rendered the provision invalid gets enjoined, repealed, struck down, or amended, which allows the language to
Okay.
be permitted.
I'm with you. I just
Okay,
wanted to make sure I was with you.
Right, so I think one of the reasons that we had suggested taking that possibility and moving it into that initial session, which is what we did with that additional language,
Mhm.
is to prevent the situation in which, how do we, if we entered into impact bargaining and we come up with an agreement,
Mhm.
what's the basis for going back to the table if we had an agreement? Do
Okay,
you see what I'm saying? Like if we get through the impact because I think the assumption is that impact bargaining is not completed. So
yeah,
if we get done and we don't contemplate what happens if it gets enjoined,
Mhm.
then I'm not sure why we would go back to the table, which is what we were trying to do, is to take that case and bring that case into the response
Mhm.
so that the effect would be, well, we already agreed what was gonna happen because we accounted for that.
So I just want to say it in my own words.
Sure.
So I make sure I'm understanding you. You're saying that we need to and I think I asked this last time too. We need to contemplate all of these scenarios to the best of our ability in that first impact bargaining session.
Our suggestion is that for all intents and purposes, we contemplate a reversal. Not in a successor agreement, but in the impact bargaining.
Right. But that all
That's-
needs to happen within that first impact bargaining session.
That is what we're proposing.
Okay,
That is what we're proposing. And that would affect that first case. What I'm referring to on ours is like case A.
Mhm.
So case B, the legislation which rendered the provision invalid is wholly upheld through a final adjudication. That's not contemplated in our proposal, and here's why. Because there isn't any effect, because the replacement language that we bargained in accordance with 24.1 covers that contingency. Because we already did it. There's no reason
Right.
for us to go back to the table, because the impact bargaining that we, like when we arrived at an impact agreement,
Mhm.
for all intents and purposes, while there may be disagreement, the assumption is that the subsequent legislation is the new sort of law of the land, so to speak. So if that, which was the basis of our impact bargaining, winds up being upheld, we don't really have to do anything because we've already done it.
Okay.
Okay, now the third case is where we split 24.2 in your proposal, which is, what if it's only partially upheld?
Right,
So in other words, they don't say it's all good and they don't say it's all bad, it's something else. this part is allowable, this part is not allowable, they come up with some other description from, and as for the case, and then, so that's why we would say in KC, the legislation which rendered the provision invalid is partially upheld through a final adjudication, and that's when our language would kick in. The university agrees to engage in collective bargaining regarding the provision with the intent of preserving the language to the extent it is permitted with the final adjudication. So that would be, we're sort of, leaving the door open to go back to the table at that point.
Mhm.
That was kind of our intention. So our understanding of your proposal is that without contemplating that second half of our case 2, where it starts with additionally, such replacement language must include considerations, that's not there. So we impact bargain it, right?
Mhm.
And then the first possible case is the legislation which renders the provision is enjoined, repealed, struck down, or amended in such a way that permits the provision's enforcement. The language of the provision takes immediate effect. The problem is that we hadn't, what if we impact bargained it? I guess that's our question is like, so what becomes the legality? Like, what is the basis for now returning to the table?
Mhm.
You know what I'm saying? Like, without putting a specific provision into this says, hey, we're gonna bargain this again, because that becoming enjoined doesn't represent a violation of the contract if we sign an MOU. I don't know if I explained that very well. Does that make sense?
I think I understand what you're saying.
Yeah.
Which is. I think we're just saying the same thing with different words.
Okay.
And correct me if you're thinking something differently. I'm imagining we go to impact bargain if we have to,
Right.
right? We come out with a resolution.
Mhm.
And if something is then, like, similar to exactly what you're saying, right? If something is then enjoined, upheld, whatever, the language that we have already impact bargained will go into immediate effect. Does that make sense?
Well, no, this is talking about returning the original language to effect. In other words, our interpretation of this provision is that it erases the impact bargaining.
I'm sorry, what are you looking at exactly? Our last proposal?
Yeah, so I put the reference here, so it would be 24.1B, so the case where you have a legislative invalidation.
Right.
And then 24.2A, which on your proposal,
It's right here.
yeah,
You guys had just had them together and I didn't change any language in our last counter. I just broke them into 2 scenarios. I broke them into A and B.
Yeah,
right, from
Right.
your last one, but not from our last one. I think there was more of a difference between our last 2 that didn't actually show on the thing.
Okay, to the best of my knowledge, I literally made a copy of your last one
Okay.
and then just split it into A and B.
Gotcha, but
yeah,
yeah, so
this is the last one we proposed.
yeah, so we're talking about 24.2A.
Hang on.
Okay,
Which is contrary to law but becomes legal. So you're talking about in just regular 24.2 shall take immediate effect upon the enactment of such legislation?
No, I'm talking about A. Because our interpretation of that provision is blind to having a successful impact agreement.
right, so the language that you have, which, is different, just covers that contingency, where if we've already finished, impact bargaining, then it would say, what do you do if, in the case of changes to these laws?
Exactly.
I hate to make it even more complicated.
It's
I
okay.
think this is really only, to my brain, this is only an issue if we're mid-impact bargaining. Because if we've completed impact bargaining and we
Right.
have language,
Right.
that language would just go into effect. It's already been agreed upon and it's the most recent version.
Okay, so I'm glad we're having this conversation because our read of this provision
Uh-huh.
is that the language in the provision taking immediate effect is the original provision, not the impact provision. The way that's written in line 21, if any provision of this agreement is rendered invalid by subsequent enacted legislation is, okay,
Uh-huh.
the subject of this provision is the original language. That is our read of this proposal.
Okay. So we just need to add in language that specifies that impact bargaining has happened.
Well, so I think the problem is that impact bargaining is supposed to resolve this issue. Because if we, let's say we don't impact bargain, then this makes sense. In other words, let me give you the scenario where we don't impact bargain. If we
Mhm.
don't impact bargain, we say, there's a provision, there's this piece of legislation that's come out, it has invalidated this provision. But we're not gonna bargain the impact with you. We're just telling you, we're no longer enforcing this provision. We're effectively striking it out of the contract unilaterally. We're not gonna talk about it. We're not gonna come up with a replacement provision. We're just gonna draw a line through it. We're no longer enforcing it.
Mhm.
Okay, without impact bargaining, and then this could come into effect if any provision is rendered invalid, but then that is enjoined, repealed, or struck down, so it just automatically comes back.
Well, we had talked about a scenario in which impact bargaining would simply be to agree that the language was unenforceable. But that language is retained.
Right, which is what we were attempting to was what we were trying to capture in the second half of our case too, which is the fact that such replacement language must include considerations of which provisions are to be enforceable if the subsequently enacted legislation is enjoined, repealed, struck down, or amended. That's what we were trying to contemplate and forcing us to include that in the impact bargain.
And I think that's, I honestly, I mean, I'm gonna say that, I think that's a good inclusion. I think the issue I run into there is that we have no way of knowing how the legislation would be enjoined, repealed, struck down, or amended. So we would have to basically in impact bargaining encompass a million different ways of which it could be changed. I think that, I mean,
Yeah,
I think
it's gonna
if
get
impact bargaining
ugly.
is done and it would be amended to modify what is allowed and what isn't allowed, I think we would just go back into impact bargaining and say, okay, this is the final decision of the courts or the laws. Let's go back in and say, what can we do now?
I think you're 100% right, which is why we split into 3 cases. Wholly upheld is fine.
Yeah.
Wholly rejected is fine. If it's partially upheld and it's along that continuum that you were
We
just
go into
describing,
impact
we go back to
bargaining
the
too.
table.
I think that's fine, honestly.
That's what we were
Did
trying to,
you-
it's super, I'm not trying to make it more complicated than it is. Like, I realize it's almost obnoxiously complicated.
Yeah.
I'm not trying to make it more confusing, but I think the intention is shared.
Yeah,
I think that's fine. Did you write up the language so that we could contemplate it as an article?
I will send it back to you.
Okay.
Again, it's no different than what we previously proposed.
Uh-huh.
I'm not suggesting any differences. I just was trying to do a better job putting them side by side so you could understand like what our intention was
Okay,
in terms of the way we drafted it.
Alright, I think the confusion is I think we crossed our wires at some point, because our intent with our last one was to take your previous proposal
Yeah.
and just split up the provisions. And maybe we just used the wrong
Okay.
version to change
Yeah.
the
That's
language,
fine.
but
We'll go ahead and I'll send it back to you.
yeah, we'll review and go back through it, that's
Okay.
fine.
it's a weird process, yeah.
Appreciate the opportunity to talk about this one again. I know that one's been kind of difficult.
No worries,
Okay.
thank you.
And I think that's all we have for today. So now you're welcome to,
Okay. So we have a couple here today, and I've split them up so I can just give everyone a copy of everything at once.
Okay.
To make it a little bit easier, hopefully.
This is just a stack for me.
Yep, that's just a stack in
Nice.
order. It should be in the order that we'll be discussing them, just to make it really clear.
Okay.
And then if anyone wants to look at either of those, should be backwards with those. It's, each stack is at one copy of each of the proposals we'll be giving out to everyone today. So we'll start with Article 16. Yeah.
I'm sorry. Thank you.
Article 16 is one of those where we've been, stuck in a rut, I think, for a little bit. We haven't kind of made any progress on this. And so this is a fresh proposal from GAU, but it is very much CCL on a lot of things. I think when it comes to release time, we're not interested in getting rid of that. It's vital for the organization of the union. It's vital to keep it there. We have gone back to CCL in terms of the FTE units requested. This had started out at 6.5. We've gone down to 4.5 to make it around 0.5 FTE number. University of Fuller continues to reject that. So we've gone to 4.32, which is CCL. We have kept the other language changes as we've discussed them. So the standard release time being 0.5 FTE. We've kept that in there because we don't believe it really changes much. And then we've kept 16.6 and 16.7, which are new separations of the article. We've kept those from our previous proposals as they were.
Okay.
And that's it. It's that is our proposal on 16.
Okay.
So we'll move into Article 13. Give me just a second to pull that up. Article 13, we had a bit of a discussion on in terms of connecting sort of these definitions to existing university, state and federal definitions and policy. We looked through UF regulations and policy. We looked through some of the state things. And to be quite honest, while obviously the University of Florida prohibits discrimination in all its forms, they do not have a sufficient definition of discrimination within their regulations and policies that we could find when we were looking through those articles. And so while there might be a definition somewhere and we've missed it, we believe in the essence of defining discrimination, especially for GAs who are going to be looking at this and wondering if they, have been discriminated against. Having a definition in there is vital. So we've put that direct definition, and then we've just removed those connections to the other regulations and policies as they are. Further down, when it comes to sexual harassment and sexual discrimination, those are defined under UF policy and federal law. So, we have that. We did not keep the second section there. We have kept our definition of sexual harassment. That's something that we had in previous proposals, and we kept it there. So we've just refined basically A and gotten rid of section B there to state sort of how to deal with conflicts in these agreements. And then we scroll further down. I believe the only other change here now is in line 83 and 84, which goes into medical confidentiality. And that last subsection, including those that contain information about their gender status, such as the sex they were assigned at birth. That's something that we think is vital for this, what we know is vital for this article. And so we've kept it in there for our proposal.
So I guess my question is, do you believe, is the intention of the proposal or your understanding and interpretation of what is contemplated in line 81, specifically the requirements of HIPAA and FERPA, right? Because that's what's contemplated in this provision. In accordance with the requirements of HIPAA and FERPA. Is what you have added in, do you believe the intention of what you've added in lines 83 and 84 increases the scope or not of what is protected by HIPAA and FERPA?
I have that experience on HIPAA and FERPA to say if that goes again, if that expands what is already required by the university. Our, goal here and what we stated before is that we want that information to also be treated in that same status as highly confidential. So if that is an expansion and you would rather reword that in a different way to get that same intent, we'd be happy to hear language on that. But our intent is for that information to be treated with the same confidentiality status.
I understand. I guess I understand what I think you're attempting to, what I think I understand the interest. I guess what I'm saying is the way it's written, the entire provision is in accordance with the requirements of HIPAA and FERPA, which lays out the parameters of the provision, right?
Okay.
And then we say, including those that contain information about their gender status. And my question is, do you believe in your proposal that there are those referring to medical records maintained by the university that are not covered by HIPAA and FERPA that contain this information? Because if so, then the provision's unenforceable. Because it says in accordance with the requirements of HIPAA and FERPA.
Okay.
So either what you're contemplating is covered by HIPAA and FERPA already, or it's not. And if it's not, then it's not in accordance with HIPAA and FERPA, if that makes sense.
I mean, that makes sense. I think our intent is clear. I mean, if there's different language to make it more clear, to make sure that that would be enforceable, then we're happy to have language on that. I think our goal is not to say we define what HIPAA and FERPA is and to go against that. I think our intent is clear, so.
Right, and my question is, okay, so what are the records that you're worried about are not covered by HIPAA and FERPA that you want to make sure we protect?
That,
I mean, there was that whole situation like a year and a half ago where the university was asked to disclose. I mean, like, I don't think it's very veiled that we're trying to address the things that have already happened.
Yeah, but the specific, I guess what I'm saying is because we were talking about a very specific, and I'm not an expert on HIPAA and FERPA either. I mean, I know enough to be dangerous, but I'm not, it's certainly not my area of expertise. It appears as if there's an interest in records that are external to those protections and you want to increase the protections. And I guess what I'm saying is that, well, then we can't use, if it's over and above what HIPAA and FERPA are.
Okay.
Then we need to know what the parameters are that you're seeking or the specific records themselves, because it's not as if we could say, oh, well, they just want the ones that are protected by HIPAA and FERPA. Well, if it's not those, then we don't know which ones it is, because it's not in accordance with HIPAA and FERPA, if that
Okay,
makes sense.
I mean, we could just
We can
get rid of the
do
first sub clause on
Yeah,
that.
we can
sentence
do
as
some
well.
research and bring it
I think the
back.
rest of the thing would stand by itself.
We're still gonna wanna know what records you're talking about, I guess is what I'm saying. Like, cause you're contemplating that there's medical records that we don't keep private. Cause that is what this augmentation implies, that there are medical records that we maintain that we don't keep private.
I mean, weren't patients' gender identities and sex at birth released to the state?
I don't know.
I mean, I'm pretty sure they were.
Yeah.
I'm not 100% sure, but
But was that part of a confidential medical record or was that part of a demographic file? Because, for example, like the files that I give you, the reports that I give you all,
Mhm.
some of that is not considered medical information, some of that is
Mhm.
considered demographic information. And again, this is not an area I'm an expert on, but like,
Mhm.
for example, you know, because I have to give you, like, I give you guys the reports all the
Right.
time, it's got all kinds of information about folks.
Yeah,
That's not a confidential medical record, that's what they call a roster record.
I mean, yeah, that's fair.
So again, I think that the specifics about which specific record you're interested in, I think is very important to being able to properly respond to the provision.
Okay. Look,
Okay.
we
So if you
can,
could look at that.
we
that would
will,
be
we'll look
helpful.
at how to refine that, to keep the same intent, but make it more clear perhaps.
Mhm.
Okay,
Any other questions on 13?
Shane, or wait, hang on. Shane or Judy, did you have any on that one? Or Robert?
No.
Okay, we will go into Article 10 then.
Okay,
Before we get really into it, we do have a little presentation for you here about what you're gonna see. It's a little bit confusing, what we've done before, so very similar presentation. We've given a couple before on stipends, but especially for people in the room, people haven't been paying attention or haven't been to many bargaining sessions. It's good to kind of say where we're at and where we started and where we want to end. So kind of overview on how we approach stipends and pay rates. Our first proposal every time we open bargaining is a living wage within Alachua County as defined by the MIT living wage calculator. We don't think that's an unfair thing to go for. We believe we know that's what GAs deserve at a minimum. And so we always start from that point. Obviously, the living wage increases every year as the cost of living increases. And so we always start there. UF has stated before that they do not believe GAs are deserving of a living wage due to our less than 1.0 FTE status officially. Our position has been and remains that UF cannot rely on our labor and also use our part-time status to not pay a living wage. And we are salaried workers, but we are training for professional vocations. All of us come into this field with degrees already. We are doing specialized work, and that is deserving of a living wage at a minimum level as we continue to keep the university as great as it has been. So we have some graphs here. We've discussed these graphs before, but I really want to dive deep into some of these things. So this is the buying power of sort of our stipends over time. And as you can see, this is kind of compared to what the 12-month minimum stipend is, compared to what our current is, and compared to the minimum wage in the state of Florida, which is that red line. It's really important to pay attention to how that red line compares to the yellow line, which kind of shows you that while we do have more buying power a little bit over time over the last several years, the minimum wage has also crept up on us to the point where our minimum stipend is pretty much equivalent to the minimum wage in Florida. And that's just unacceptable across every metric. We will look kind of further at this.
can I ask you a question about the previous
Yeah,
graph?
of course.
Sorry. Can you go back?
Yep.
So when you calculated the annualized minimum wage?
Yep.
That was predicated on working how many hours?
That's predicated on working full-time, which is what
Okay.
GAs are, GAs work full-time for what they're allowed to do, so.
What does that mean full-time for what they're allowed to do?
GAs are limited by how many hours they can officially work by the government. Officially, of course, but, we've already discussed overwork to a significant degree, during the bargaining sessions,
Gotcha.
so. So when we look at our 12-month minimum stipend versus the cost of living, you're gonna see something very interesting, which is that while the stipend has grown a little bit over several years, the cost of living has vastly outpaced what that minimum stipend is, which is why we discuss this and why we push this so hard for a living wage. Because while we were paid close to the cost of living as of 2017 and 2018, we no longer are, even with the raises we've gotten, and that makes every single GA makes it harder to pay rent, harder to buy groceries, and harder to live within Gainesville. And so that's something that is causing, all of these issues here. We zoom in again on sort of the minimum stipend versus the minimum wage versus the year. As you can see, as of a couple of years ago, we were paid a little bit of a premium over the minimum wage, but that has dipped to about 100%, about the same rate. So, paid the same as someone who is not doing as skilled of work at us. And while they do deserve more money as well, GAs come with degrees, they come with specialized trainings, and they're doing specialized research, so. And this is the really one where we really want to kind of show where we're at over several years. GAs have gotten raises over this time frame, but they have not kept up with the cost of living to the point where while we were paid close to the cost of living in 2017, 2018, it's just no longer the case. We're at 61%. That number continues to go down every year. And it's at a point where it's unobtainable for GAs to, they're going to have to start thinking not about going to the University of Florida for a degree, but saying if they could even afford to live here. And for many GAs, the answer to that is no, they can't afford. So first question we've asked this question before is, can the University of Florida afford raises? When we look at basically any statistics we can, admins received raises over the last few years. UF has had a great increase to their net position over the last few years. Their assets have increased by 70%. Our former president is getting $1 million per year. And they had so much money left over previous years that they were able to give out bonuses to exceptional tenured faculty without the need for bargaining through their own union, just given out to them, which we think is great. We think obviously faculty deserve that. But a 10,000 bonus to GAs when we're only making 20,000 would also be a huge boon. So they have the money, very clear. Is UF financially secure? Are they on an upward trend, on a downward trend? We've talked about this before, and by every metric you look, yeah, they can afford it. They've got a positive debt outlook. Our Board of Trustees chair was, stated the University of Florida was in a strong position to do great things, just not great things for GAs apparently. Our interim president says we're on an incredible trajectory, but GAs are being left behind on that. We're being left flat. And even the S&P revised the outlook on UF's market position, saying that they had exceptional metrics by any way you look at it. So is UF financially secure? The answer is once again, yes. Big thumbs up from us. We know that. So final question, if they can't afford to do it, and they have the money to do it, are they willing to do it? Are they willing to spend more money on GAs? And thankfully we have an answer to that. And it's that they're not willing to spend more money. I don't know if you guys could hear that, but they're not willing to spend any more money. So that gives us the kind of the answer of what we're going for here. They're not willing to spend more money. And we came back as a team and we thought about how to kind of address the idea of, the Board of Trustees not being willing to spend more money on GAs. And the fact of the matter is that we don't care. This union exists not because the Board of Trustees has historically been willing to give GAs raises. It exists because the Board of Trustees historically cannot be trusted to make that decision for themselves. The Board of Trustees has not given GAs the raises that they deserve, and this union has remained for over 40 years because of that fact. So the Board of Trustees may not be willing to spend more money on GAs, but they're willing to exploit the work of GAs, and they're willing to underpay us as much, every day. And so we don't really care that they're not willing. That's not the point of negotiations. So we have four proposals for you today on Article 10. There are four different kind of ways we think that we have forward. So first option is a raise to the minimum stipend to 21,600 for a 9-month 0.5 FTE. That matches what our last proposal was. It's $1,000 over what the University of Florida has remained at for close to a year now. And we believe that's fair. If with that proposal, you'll see as well that the other three issues we're going to discuss here are back to what the University of Florida has provided in their recent contract. So the only change would be a raise to that minimum stipend. The second option the University of Florida has is to waive all fees for UF. This is approximately the same cost, but this would be a huge relief for all GAs. It would save us an entire paycheck each semester and ensure that, you know, we are not getting stuck with a random $600 bill in the middle of each term. So that would be a huge boon to all GAs. The University of Florida has shown time and time again that they love the merit raise above everything else. If you raise the amount for the merit raise to match what we've proposed before, we think that's fair. We think that would give all GAs at least a little boost until we can reopen bargaining again and continue pushing after that minimum stipend. And that would be a good option. And option 4 is to stop UF's abuse of the waiver we gave them in 10.5. This is the waiver that the University of Florida used a couple of months ago to give all GAs raises while we were still in the midst of bargaining. While we believe GAs getting raises is always a good thing, the fact that the University of Florida chose to do that while we were bargaining and with no sort of respect for the bargaining process, even though they were allowed to do it through this waiver, obviously they cannot be trusted to continue keeping that waiver. And so one option would be to eliminate that for the language that we proposed before for 10.5. And that's our four proposals for you, as they are. And the text should match all of that.
You have any questions? Shane, Robert, or Judy, do you have any questions?
No.
You have any questions? No? Well, that's all the proposals we brought today.
I would love to just say, very clearly looking at these options, there is a free one on the board as well.
Mhm.
Which we are very acutely aware of.
Yeah.
We want to see movement. I think we've said it over and over and over and over.
We bargained against ourselves time and time again. University of Florida, after 6 months of making us wait on a fresh proposal, gave us the exact same thing, but in different writing. And it's just ridiculous. We want to get this contract done. We want to move on and let GAs have the raises that they deserve. Obviously, University of Florida is not willing to give them the raises that they deserve, so we're going to get as high as we can. And then we're going to reopen Article 10 later in the year. So we believe these are fair options, but you know, those are the only four options that we see moving forward.
All right.
Well, you think the university would be eager for some good press after their president's frankly for spending? I know national championship is great, but it'd be great to see.
Are we done?
It's like,
I think we've had a shorter session, so I think we have time for a couple of comments from the audience if they do want to give some comments while we're all here. And maybe has anyone things specific to say on Article 10, and you want to keep it to a minute or two, that would be perfect. A couple of people. Cool. Anyone wants to do that? You don't have to, don't feel pressured.
Sorry, I had a question.
Yeah, of course.
Don't we need to schedule the next in-person meeting or future meetings?
We can do that over email. We don't have any scheduled right now, but yeah, we still have to collect what our availability is for the bargaining team and stuff as well, so.
Any questions about?
Yeah.
Option 1 only contemplates 9 months.
Yeah,
Yes, that's for 9 months.
so I did not list the 12-month stipend, but our 12-month stipend is always whatever the 9-month stipend is times 4/3. So it would be, I don't remember the exact value here. I don't know. Twenty-eight,
Yeah,
800?
28,800.
Yeah, so that would be what it would be.
Mhm.
Any other questions or comments on these?
Before the UF staff heads out of the room, who in here, hello, GA, please. Who pays more than 55% of their monthly income in rent, just your rent? Since we're here and you can see us. That's all I have to say. Thank you.
Thank you. Yeah, of course.
That's a question. So how would the increase in stipend compare to the monthly living expenses?
So the current living wage, in Alachua County is over 40,000. So we are still a way off from a living wage, which is where we started, over a year ago. We've given University of Florida several proposals kind of moving down that track. One of them is matching them to the F1 and J1 income requirements, which the University of Florida sets. We've tried using that as a minimum, and they still denied that as well. So this is still a premium over what the current minimum stipend is, but still a far way off from a living wage.
This is the first time I hear about merit raise. What does that imply? Like, what's merit?
Merit raises were added during our last Article 10 session, where it's just a raise given to GAs who
Are
pass.
in good standing, are continuing, there's like 4 criteria.
Are good standing or not recommended?
Yeah,
Yeah,
the vast majority of GAs would get those merit raises. If you don't get like an evaluation from your department, you would receive it as well. And a lot of departments don't do those evaluations as well as they should. So this would be based off of whatever you're paid right now, you would get, if you're a 9-month and additional, $13.50 prorated to last October 1st.
What happens when they abuse the waiver?
What?
What happens when they abuse the waiver?
When they abused the waiver, they showed disrespect to the bargaining process. They gave all GAs raises matching what their previous proposal was, while we were still in bargaining, while we hadn't heard a proposal from them in several months. And while the waiver allows them to do that, it was disrespectful to us, and that's how we continue to view it. Even though they defend that they were allowed to do it, we don't believe that that is something that they should keep. You know,
Bargaining just
It's,
like
it's not our
force us to
opinion.
that.
It's not our opinion we're allowed to do it. It's a ratified contract that permits us to do it.
But basically.
You may not like it,
But
but
basically, per current language, they can just go ahead and give it without actually agreeing to anything else, you know, or giving up anything or.
So we
or
cannot,
moving
like,
Or guaranteeing it will continue in the future. Well, that's the biggest one, is that like,
So they give us a raise and then that just messes with the current bargaining, so we're gonna ask for more, is that what you're saying?
well, it messed with it because they had dug in their heels for several months. So while we were still negotiating and trying to get a higher raise as possible, they, instead of just, you know, saying they were done giving raises, they also implemented them, which just kind of shows that they, you know, aren't waiting for the ratification either way, even after we had proposed previously language that would allow for immediate raises to go into effect once we agreed on Article 10. We had proposed that, they had denied those sort of language, and then they implemented the raise regardless.
it's an effort to get around.
Yeah, it is. It's a waiver that has been in Article 10 for a while, and it's one that we're no longer interested in keeping in the language as it currently is.
and it's free to change.
It is free to change. Yeah, we have a couple questions. You?
Yeah, I'm just a faculty member here in Solidarity, and I apologize that I don't know the answer to this question already, but what's the current 9-month stipend? And could you remind me of the rough size of the bargaining unit?
So our bargaining unit is roughly 4,000 VAs, a little over. I don't remember what the current.
It's exactly $1,000 less than this for a 9-month. It's 20,600. And for 12 months, that's equal to $27,467.
And technically, it's per our current contract, it's less than that because the raise that they implemented is $1,000 less than that, but they had implemented a raise over what our current minimum as per the contract is.
Yeah,
So,
our contract currently says 19,200.
yeah.
So I'm not a math person, I teach writing, but if I'm doing some very quick mental math correctly, the marginal cost of what you're proposing is about $250,000.
No, it should be closer.
Do you guys want to do your meeting? Because, I mean, if you guys want to talk to your folks, that's fine, but we don't need to sit here and listen to them. I mean, if they have.
I think these are valid
information
questions that the University of Florida would hear that people have about these issues.
About this,
Also
the
the margin-
size of the bargaining unit, like,
Yeah, and the current minimum stipend and how it relates to the living wage, we think that's vital information.
I'll sit here,
Faculty here who wanna talk to you.
which is fine. They have no, I don't have to talk to faculty during your bargaining session. They don't have any standing to talk during a bargaining session. They're not members of your bargaining unit.
They have permission to talk when we ask them to, if we're asking members of the public, because they are members of the public.
Yeah, also, wait, sorry. The
Yes,
question of the marginal cost is probably an answer, question that you're better suited to answer than we are, because I mean, if there is additional costs that you guys are aware of that we're not, like, we're just counting how much more it is times 4,000. Are there additional costs?
So you'd like us to calculate, I'm happy to calculate the cost of your proposal.
Well, no, I'm asking, are there additional marginal costs beyond just like the value of the increase? If it's just.
Yeah, I mean, of course, there's a factor for fringe, there's a factor for benefits. Yeah, there's all kinds of additional costs that go into adding, and I'm happy to share those. I mean, those are not.
That's exactly the point, like, you are the person who should be able to answer those questions instead of just packing your bags and deciding to leave.
Okay, but I'm happy to, so the way that bargaining typically works, I can't believe this is the bargaining session now, is that each side is responsible for doing a cost analysis of the proposals they bring. It is normally not, and the other side may choose to do an analysis on their own, but it's pretty atypical for one side to bring a proposal and then say, cost this for me. I'm happy to do that, but
No,
it's
we're
pretty
more than
unusual.
capable of doing that ourselves, and we have not done that for this specific proposal, because this one is a step down from where we've been before, so the cost as it relates to the University of Florida's entire budget is not significant in any regard. Our last proposal we gave, I guess 2 proposals ago now, because we give enough, which was several $1,000s above that, was in the ballpark of around $35 to $40 million as we calculated, including the fringe rate, which, when you look at it on a big scale, it could seem like a lot of money. When you look at how much Ben Sachs gets for his retirement plan, it's about 9 of those. So this one's probably about 1 to 2 Ben Sachs's. Yes.
I have a question to my fellow VAs in the room. Has anyone ever had to miss a bill or skimp out on groceries because of the fees that they have to pay? Can you raise my hand?
Thank you. Yeah, any other things that the University of Florida would be great at answering for these? If not, we will let the University of Florida go, but yeah.
Oh, I was actually wondering if they could explain, because like my advisors are in the Zoom, if you could like explain to them why you believe their students don't deserve to live, like enough money to live.
I've never said that, so by answering the question, no, I'm not gonna answer that question.
Does University of Florida pay a living wage to GAs?
The way we've calculated it, absolutely.
According to what standards?
Are back and forth with your folks, is that what we're doing now? Like, we're gonna do back and forth with the people that aren't.
To defend your position or
No, I'm not going to defend it to you. You're not a member of the bargaining team. This is not productive. This is not what bargaining is, Austin. Engaging with members of your bargaining unit in a free-for-all is not the way bargaining goes. That is not how bargaining operates.
Using the waiver to undermine the process and then say at the bottom, we are gonna continue in good faith to negotiate and keep shutting it down is not just disrespectful. I don't even know what to say. It's shameful. And
So
it's
which of the provisions of the contract do you want us to stop following? Because it's a provision of the contract which we're permitted to follow,
Yes.
that you have ratified
Yes.
multiple times, at least 15 times, you've ratified this provision. I get that you don't like it, but to say that we're using a provision that you've ratified is in some way, shape, or form a violation of the contract, no ULP filed, no grievance filed, none. I get that you don't like it, but characterizing it as an abuse of the contract to follow the contract is very obviously confusing to your bargaining unit.
It's abuse of the contract to avoid bargaining. We're not saying that you did it illegally. In fact, we've said several times, it was done completely legally. It's 10.5, you did it, it's fine. You told us last time that you've done it before.
Yeah, the
But-
last time we were in full book, we did it.
But what it doesn't satisfy is the fact that you implemented your proposal.
Right.
Right, and then you have not given any subsequent movement, and we think that that's done in bad faith, and we
Okay.
think it's an abuse of the contract. Yes, it was not illegal. I don't think that's confusing.
Yeah, we're not saying it's not, but you did it, so we don't want it to happen again.
For the record as well, we have, the changes to Article 10.5 does not eliminate the ability of the University of Florida to give raises to individuals who deserve it and to pay GAs varying amounts for the different work they do. It limits the amount they can do and make sure that those changes do not happen during bargaining, to respect the process as we're going through it in future times. So we believe it is a fair sort of limitation on that. Obviously, the way we had it before, there was trust involved to ensure that it would not be abused, that GAs could be paid and giving raises, individually. And that trust has been abused, and so, we're going to reduce that waiver. I think at this point,
Yeah.
we're gonna call it unless there's something really pressing in the Zoom, but I haven't seen any comments. And
We
we'll
can
let you-
discuss further in debrief.
Yeah, we do have our debrief, so hang around for a little bit.
And next session, we're gonna do over email, figure out like when we're gonna do a next one, or are we on for next Friday?
We don't have anything booked for next Friday for a
We
room.
can Zoom, but I'm not allowed to book rooms in the rights union for, like, it's a 2-week waiting period.
Gotcha.
Yeah, yeah. So we'll
So
let you
we
know what
can
our
meet
plan
in
is.
person somewhere else or, on Zoom.
Okay.
See ya.
For anyone who's in the Zoom, we will drop a link for the debrief. Thanks for anyone who's heading out for
Yep.
coming.
Thank you, guys.
Thank you.
Greatly appreciate your being here. Anyone who's in the back, please feel free to